5 seconds to go. Start. The learned counsel for the appellant has questioned the impugned order inter alia on the following grounds. The High Court did not follow its own decision rendered by a coordinate bench which had affirmed an earlier decision rendered by a learned single judge. Judicial propriety demands that if a bench of co-equal strength disagrees with an earlier view, it must refer the matter to a larger bench. Failure to do so renders the decision vulnerable. Therefore, the impugned order should be set aside and the matter be remitted back to the High Court for a fresh decision. It has been submitted that Section 59 and Section 95 of the Act must be harmoniously construed. Moreover, Section 59 opens with the phrase "save as otherwise provided in this Act," which signifies that the executive power of the Commissioner is subject to other provisions of the Act. Further, Clause D of Section 59 itself makes the disciplinary power subject to the regulations. Therefore, when Clause D of Section 59 is read conjointly with Section 95, which provides that punishment may be imposed by such authority as may be prescribed by the regulations, it becomes clear that where the regulations specify the authority competent to impose punishment, it can be imposed by that authority and by no other authority, not even by the Commissioner. It has further been submitted that as Clause D of Section 59 was brought by substitution, it would be deemed to be incorporated in the original statute, and since it opens with the words "subject to any regulation made in this behalf," the disciplinary power envisaged thereunder would remain subject to the existing regulations. There is nothing in the amended provision to indicate that it overrides the existing regulations. If the interpretation adopted by the High Court is accepted, there would be an unresolved conflict between Section 59 and Section 95 of the Act. Such an interpretation, according to the appellant, must therefore be avoided. It has also been urged that the existing regulations are protected notwithstanding the amended. According to the appellant, for the purpose of interpretation, there is no distinction between repeal and amendment, and therefore the regulations framed earlier would continue to operate. Per contra, learned counsel appearing on behalf of the respondents submitted that the object of the amendment was to streamline the municipal administration. It was argued that a statutory provision introduced by amendment must be construed in a manner that advances the object sought to be achieved by the legislature. The legislative intent, according to the respondents, is clear in making the Commissioner the disciplinary authority in relation to all municipal officers and employees. It was further submitted that the words "subject to any regulation that may be made in this behalf" would mean regulations that may be framed after the amendment. Otherwise, the legislature could have used different language or omitted the expression "that may be made in this behalf" altogether. The very use of these words indicates that the provision is intended to operate subject to failure. Stop.